सो वेलकम बैक दोस्तों। आज हमारा है आखिरी एग्जाम बचा है कुल मिलाकर, और ये एग्जाम है MMPC 013 दैट इज बिजनेस लॉ। हम पहले डिस्कस करने वाले हैं जून 2022। सो मेरा जून 2022 के प्रॉपर को फोकस करना रीजन ये है क्योंकि मैंने पिछले वीडियोस में सिर्फ जून 2022 का एक मात्र पेपर सॉल्व किया था, एंड आउट ऑफ 8 क्वेश्चंस 4 क्वेश्चंस में से फंस गए थे। तो आप ये यकीन मानिए 5 ही हमें करने होते हैं और 80% मेरा एक ही एग्जाम से आ गया जून 2022 से। तो मुझे पैटर्न थोड़ा थोड़ा समझ में आ रहा है कि जून 2022 और जून दिसंबर 2023 यही दो एग्जाम्स हैं जिनमें से हमारे पेपर फंस रहे हैं। तो इसीलिए मैं पहले जून 2022 अभी डिस्कस कर ले रहा हूँ, और इन द मीन टाइम अगर मेरे पास टाइम रहा तो मैं दिसंबर 2023 भी डिस्कस कर लूंगा। चलिए अब डिस्कस करते हैं। सो क्वेश्चन फर्स्ट है हमारा, डिफाइन बिजनेस लॉ, डिस्कस द ऑब्जेक्टिव्स ऑफ बिजनेस लॉ। डेफिनेशन ऑफ बिजनेस लॉ. Business law, also known as commercial law or corporate law, is the broad branch of law that governs the rights, relationship, and conduct of individual companies and organizations engaged in commercial merchandise, trade, and sales. It encompasses the legal framework within which business are created, operated, managed, and dissolved. ठीक है जी, बिजनेस लॉ समझ में आ रहा है। इसको कमर्शियल लॉ या कॉर्पोरेट लॉ भी बोला जाता है। ब्रॉड ब्रांच है लॉ की जो गवर्न करती है राइट्स, रिलेशनशिप और कंडक्ट ऑफ इंडिविजुअल्स के रिगार्डिंग। ठीक है, मोटा मोटी आपने ये डेफिनेशंस को अच्छे से याद करना क्योंकि लीगल लैंग्वेज है, आपको अच्छे से लिखनी पड़ेगी। फिर है एसेंशियली बिजनेस लॉ प्रोवाइड्स द रूल्स एंड रेगुलेशंस दैट इंश्योर फेयरनेस, ऑर्डर एंड प्रेडिक्टेबिलिटी इन द कमर्शियल वर्ल्ड. It covers a vast array of topics from the fundamental principles of contracts and property to more specialized areas like intellectual property, employment law, corporate governance, consumer protection and antitrust regulations. ठीक है, अब ऑब्जेक्टिव पढ़ते हैं बिजनेस लॉ के। द ऑब्जेक्टिव ऑफ बिजनेस लॉ आर मल्टीफेसेटेड and aim to create a stable, ethical and efficient environment for commercial activities. की ऑब्जेक्टिव क्या होते हैं आप समझिए, बिजनेस लॉ के की ऑब्जेक्टिव क्या है। पहला की ऑब्जेक्टिव है इसका, इस्टेब्लिशिंग अ फ्रेमवर्क फॉर बिजनेस ऑपरेशंस। ठीक है, एक फ्रेमवर्क बना के देना बिजनेस ऑपरेशंस को स्मूथ करने के लिए। फंक्शन, बिजनेस लॉ प्रोवाइड्स द फाउंडेशनल रूल्स फॉर हाउ बिजनेस आर फॉर्म। एग्जांपल सोल प्रोप्राइटरशिप, पार्टनरशिप्स, कंपनीज, हाउ दे ऑपरेट। एग्जांपल कॉर्पोरेट गवर्नेंस, मैनेजमेंट स्ट्रक्चर एंड हाउ दे आर इवेंचुअली डिसॉल्व्ड। ऑब्जेक्टिव्स क्या होते हैं? To provide clarity and certainty regarding legal entities and their legal standing, making it easier for individual and groups to organize and conduct commercial ventures. ठीक है, facilitating commercial transactions. It lays down the rules for various business transactions, most notably through contract law. This includes defining what constitutes a valid contract, the right and obligations of parties, and remedies for breach of contract. It also covers law related to the sales of goods, negotiable instruments like check and promissory notes, and agencies. Objective क्या होती है? To ensure the business agreements are legally binding, enforceable and transparent, therefore fostering trust and confidence in commercial dealings and promoting smooth trades. भाई ट्रेड की बात हो या आपकी प्रॉपर्टी डीलिंग की बात हो, आप कमर्शियल पेपर्स भी साइन करते हो जिससे ही लेन देन होता है, तो किसी चीज से बाइंड करना वो हमारा बिजनेस लॉ पे काम करता है। Protecting right and interest. Business law safeguards the rights and interests of various stakeholders, including business owners, consumers, employee and shareholder. अंदर की डिटेल आप पढ़ लेना, ठीक है, क्योंकि मैं बस आपको बता दे रहा हूँ कि राइट किस किस के पास होते हैं। बिजनेस ओनर्स के अपने राइट होते हैं, कंज्यूमर्स के अपने राइट होते हैं, एम्प्लॉइज के अपने राइट होते हैं, शेयर होल्डर्स के अपने राइट होते हैं। To create a balanced legal environment where all parties involved in commercial activities are treated fairly and their legitimate interests are protected from exploitation or infringement. ठीक है, चौथा है promoting fair competition and preventing monopolies. Function, antitrust or competition law aims to prevent anti-competitive practices such as price fixing, market allocation, and the abuse of dominant market position. It also regulates mergers and acquisitions to prevent the creation of monopolies that could harm consumer welfare. To foster a competitive marketplace, encourage innovation, ensure efficient resource allocation, and provide consumers with choice and fair price. ठीक है, ठीक है, fair price competition and preventing monopolies. अब पढ़ते हैं ensuring compliance and accountability. Business law sets standards for ethical conduct, financial reporting, environmental protection, and taxation. It mandates adherence to various regulatory requirements and imposes penalties for non-compliance. Objective: to promote a responsible business practice, discourage illegal or unethical activities, and ensure that business operates within the bounds of the law, thereby enhancing public trust and corporate social responsibility. Providing mechanisms for dispute resolutions function. When disputes arise in commercial relationship, example contract breach, intellectual property infringement, employee disagreements, business law provides legal mechanisms for their resolutions. This includes litigation through courts as well as alternative dispute resolution methods like mediation and arbitration. In mediation and arbitration हम लोगों ने MMPC 10 में ऑलरेडी पढ़ा हुआ है, तो आप लिख सकते हो इसके बारे में. To offer timely, efficient, and just means of resolving conflicts, minimizing disruptions to business operations, and maintaining stability in commercial relationships. Facilitating economic growth and stability. Function: by providing a clear, predictable, and a fair legal environment, business law reduces uncertainty and risk for investors and entrepreneurs. These encourage investment, innovation, and trade, both domestically and internationally. Objective: to contribute to a stable and prosperous economic environment by attracting capital support, entrepreneurship, and facilitating efficient resource allocation. In essence, business law acts as the essential rule book for the commercial world, ensuring order, fairness, and the protection of rights, all of which are crucial for thriving. So, question second discuss करते हैं हम लोग. Discuss the modes of dissolution of partnership and explain the grounds on which a court can order dissolution of a firm. So पहले हम समझते हैं dissolution यानी मतलब उसका होता क्या है. डिसोल्यूशन क्या मतलब समझते हो, यानी पार्टनर्स का अलग होना, पार्टनरशिप का डिसोल्यूट होना. In the context of business law, particularly under the Indian Partnership Act 1932, dissolution of partnership firm means the termination of the legal relationship between all partners in the firm. समझ में आ गया dissolution? Leading to the winding up the firm's business, it distinct from the dissolution of a partnership, which merely refers to a change in the relationship between existing partners. Example: due to the retirement of admission of a new partner, while the firm itself may continue. The dissolution of the firm implies that the business ceases to exist and its assets are realized to settle liabilities. समझ रहे हो, यहाँ पे बिजनेस बिल्कुल खत्म ही हो रहा है. पार्टनरशिप कोई ऐसा नहीं कि पार्टनर गया या कोई नया पार्टनर ऐड हो रहा है, यहाँ पे डिसोल्यूशन हो रहा है. पार्ट मतलब खत्म, इसके बाद अब पार्टनरशिप नहीं रहेगी. तो ये कहने का मतलब है. तो इसका एक फिगर से समझते हैं हम, इस ग्राफ के फिगर से. इससे आपको समझ में आ जाएगा डिसोल्यूशन ऑफ पार्टनरशिप में और डिसोल्यूशन ऑफ पार्टनर्स में फर्क क्या है. इससे आपको आधा क्वेश्चन समझ में आ जाएगा. When a partnership firm dissolves, all business activities within the partnership ceases. But जब dissolution of partner होता है तो in the dissolution of partners, a firm can still work by forming a new partnership deed. क्लियर है? ये मैंने ये ग्राफ लगाया इसलिए ताकि आप लोगों को समझ में आए पिक्चर से. The assets are used to repay the debt at the time of the firm's dissolution. Only the particular partner's account is being closed and all the assets and liabilities of a particular partner is taken into consideration. यह है dissolution of partner में. Dissolution of partnership, the severance of all legal and contractual links between the partners of a firm is referred to as dissolution of partnership. When one of the partners retires while the other partners continue to manage the businesses at the time is termed as dissolution of partners and not a partnership firm. With a change in the partner, there will be no change in the firm. It will not affect the working of the firm. When there is a death of any partner or due to any other reason, one partner is no longer in the firm, that time that partnership is dissolved and a new partnership is formed. In certain cases, partnership firm can be dissolved with the intervention of the court. A partnership is dissolved without the intervention of the court. अब हमने तो देखो समझ आ दिया आपको, पार्टनरशिप आपके डिसोल्यूशन ऑफ पार्टनरशिप फॉर्म भी समझा दिया, डिसोल्यूशन ऑफ पार्टनर भी समझा दिया, ताकि आपको और बेटर क्लियरिटी आ जाए. हालांकि हमसे नहीं पूछा गया है, बट मेरा करना क्या है कि पढ़ो तो ऐसा पढ़ो कि कुछ भी आ जाए ना इससे रिलेटेड तो आप कर पाओ स्मूथली, इसलिए ऐसे अच्छा पढ़ो, कोर पढ़ो उसका. ठीक है, अब हम पढ़ते हैं मोड्स ऑफ डिसोल्यूशन ऑफ अ पार्टनरशिप. A partnership firm कैन बी डिसॉल्व इन सेवरल वेज ब्रॉडली कैटेगराइज एज, तो कोई इसका कलर समझ में नहीं आ रहा ना, कलर बदल देते हैं, ठीक है। वाइट ही करते हैं, पूरा करेंगे, हो गया। हो गया, ठीक है। डिसोल्यूशन विदाउट द इंटरवेंशन ऑफ द कोर्ट, पूरे कर लेते हैं इसको, सब राइट, ठीक है। डिसोल्यूशन विदाउट द इंटरवेंशन ऑफ द कोर्ट, बिना इंटरवेंशन कोर्ट के कैसे डिसोल्यूशन होता है। दिस मोड ऑफ डिसोल्यूशन अकर्स ईदर बाय अग्रीमेंट अमंग पार्टनर्स और बाय ऑपरेशन ऑफ लॉ सर्टेन इवेंट्स लाइक विदाउट रिक्वायरिंग कोर्ट ऑर्डर। डिसोल्यूशन बाय एग्रीमेंट, सेक्शन 40 हमारा अलाउ करता है dissolution by agreement. This is the most common and amicable way to dissolve a firm. A firm may be dissolved with the consent of all partners or in accordance with the contract between the partners. Example, a clause in the partnership deed specifying dissolution condition. देखो पार्टनरशिप डीड होती है ना, उसमें बहुत सारी कंडीशंस होती है, तो उसमें अपने सेक्शन 40 में ये कंडीशन भी है। अगर आपने लगा रखा है अपने पार्टनरशिप डीड में, आपने ये कंडीशन दे रखी है कि सारे पार्टनर्स मिलकर हमारी पार्टनरशिप को डिसॉल्व करने की पावर रखते हैं, then you can do. फिर है compulsory dissolution, section 41. A firm is compulsorily dissolved under the following circumstances: insolvency of partner, when all the partners or all but one partner are adjudicated as the insolvent, an insolvent person is legally incompetent to enter into contracts. ठीक है। Illegality of business, when the business of the firm becomes unlawful, for instance if the nature of the business becomes prohibited by law, or if partner becomes an alien enemy due to war, making a unlawful. If the firm carries on multiple businesses and become unlawful, it doesn't necessarily dissolve the entire firm, only the unlawful part. समझ रहे हो? इसमें क्या है, सेक्शन 41 में आप सिर्फ फर्म को नहीं डिसॉल्व करोगे, आप उस बंदे को डिसॉल्व कर दोगे, पार्टनर को या उस बंदे को जिसने आपके साथ गलत कर रहा है कंपनी में, जो अनलॉफुल एक्टिविटी में इन्वॉल्व है, आप सिर्फ उसे डिसॉल्व करने की पावर रखते हो एज पर सेक्शन 41 कंपल्सरी डिसोल्यूशन। Dissolution on the happening of a certain contingency, section 42. Subject to a contract between the partners, a firm may be dissolved upon the happening of a specific event, expiry of a fixed term. If the partnership was formed for a fixed period, it dissolved upon the expiry of that term. Obviously, अगर आपका एक सर्टेन टेंडर के लिए आपने फॉर्म करी थी पार्टनरशिप, तो वो एक फिक्स टर्म के लिए तो रहेगी, बाद में थोड़ी चलेगी, वही बात वो बता रहा है। फिर है कॉम्प्लीमेशन ऑफ वेंचर अंडरटेकिंग, if the partnership was formed for a specific adventure or undertaking, it dissolves upon the completion of that venture. Death of a partner, the death of any partner usually dissolves the firm unless the partnership agreement specifies that the remaining partners will continue the business. देखो अक्सर क्या होता है ना, पार्टनरशिप पे भी जब कोई पार्टनर मर रहा होता है, उससे पहले एक आपका विल वगैरह बना के जाते हैं कि भाई ये पार्टनरशिप में ये बंदा डेथ हो गया तो उसके बच्चों में वो पार्टनरशिप का वो हकदार होंगे, या फिर उनके जो भी उनके मतलब सक्सीजर होते हैं, सक्सेसर, वो लोग आ जाएंगे उसके बंदे। तो इस तरह की चीजें को वो बना के देते हैं ताकि पूरी फर्म डिसॉल्व ना हो जाए या पूरी पार्टनरशिप फर्म डिसॉल्व ना हो जाए। डिसोल्यूशन बाय नोटिस, 43. The mode applies specifically to partnership at a will, where no fixed period or specific undertaking is mentioned in the partnership agreement. Any partner can dissolve the firm by giving notice in writing to all the other partners of their intention to dissolve the firm. The firm is dissolved from the date mentioned in the notice, or if no date is mentioned, from the date on which the notice is communicated. Dissolution by the court, section 44. अब यहाँ पे court involve हो गया, ठीक है। A court can order the dissolution of partnership firm and the suit of partner on specific grounds. कैसे कैसे? Unsound mind of a partner. If a partner other than the partner suing has become an unsound mind, insane, the suit can be brought by any other partner or by the next friend to the unsound partner. मतलब अपने सही दिमाग में नहीं है पार्टनर, तो उसको क्या करेंगे, उसके लिए कोर्ट हमारा ऑर्डर दे सकता है। This is insanity need not be permanent for the court to order dissolution, but it must be such that it affects the partner's ability to participate in the business. अगर भाई कोई बंदा पागल हो गया तो वो थोड़ी परमानेंट डिसीजन ले पाएगा, तो उसकी इसकी बात हो रही है यहाँ पे। परमानेंट इनकैपेसिटी ऑफ अ पार्टनर ground in a partner other than a partner suing has become permanently incapable of performing their duties as a partner. This includes physical disability, prolonged illness, or any other factor that permanently prevents a partner from fulfilling their role. The incapacity must be permanent, temporary illness, or would not suffice. Misconduct of a partner. If partner other than the partner suing is guilty of conduct that is likely prejudicially affect the carrying on the firm's business, the misconduct doesn't necessarily have to be related to the business itself. Example, personal misconduct like gambling, provided it impact the firm's reputation or operations. The court will assess the nature of misconduct and its likely prejudice effect on the businesses. Persistent breach of agreement by a partner. Ground. If a partner other than the partner suing willfully or persistently commits a breach of the partnership agreement relating to the management of the firm's affair, of the conduct of its business, or conducts themselves in a manner that makes it not reasonably practicable for other partners to carry on the business in a partnership with them. ठीक भाई, ब्रीच कर रहा है एग्रीमेंट का पार्टनर तो भी हम करवा सकते हैं कोर्ट से. Examples include embezzlement, keeping erroneous accounts, or refusing to show the account despite repeated requested, and the breach must be persistent and significant enough to make continued partnership impossible. यहाँ पे भी कोर्ट इन्वॉल्व हो सकता है. Transfer of interest by a partner. If a partner other than the partner suing has transferred the whole of their interest in the firm to a third party, or allowed their share to be charged under a decree, or allowed to be sold for the arrears of the land revenue. That it signifies breakdown of the mutual trust and confidence central to a partnership, as a partner has alienated their fundamental interest without the consent of others. Business cannot be carried on except as a loss. If the businessman of the firm can only be carried out at a loss, the court will examine the financial viability of the firm. If it determines that the firm is consistently incurring losses and there is no reasonable prospects of turning a profit, it may order dissolution to prevent further financial detriment to the partner. समझ रहे हो, लॉस ही लॉस हो रहा है, क्या ही करेगा, बंद करो यार, कोर्ट भी दे देगा. Just and equitable grounds. If the court considers it just and equitable to dissolve the firm or any other ground, this is the broad discretionary power of the court, allowing it to order to dissolution in situation not explicitly covered by the other ground, but where it's clear the partnership has become unworkable or oppressive. Example, deadlock in management, where partners are in perpetual disagreement, making it impossible to run the business. Loss of substratum, where the fundamental purpose of foundation of the partnership has disappeared. Partners not being on speaking terms. Extremely anonymity, making cooperation impossible. This dissolution of a firm leads to a binding up of its affair, including the realization of assets, payment, liabilities, and dissolution of any remaining surplus among the partners. तो आप ये समझो हमने किन किन सेक्शंस की बात करी है यहाँ पे, ठीक है. डिसोल्यूशन ऑफ पार्टनरशिप के लिए हमने कौन कौन से सेक्शंस की बात करी है. पहले हमने बात करी है सेक्शन 40, दैट इज डिसोल्यूशन बाय एग्रीमेंट. मैं आपको दिखा भी देता हूँ, वरना आप देखोगे नहीं तो आपको समझ में नहीं आएगा ना. ठीक है, आप देखिए, हमने पहले बात करी डिसोल्यूशन बाय एग्रीमेंट सेक्शन 40 की. उसके बाद हमने बात करी कंपलसरी में डिसोल्यूशन सेक्शन 41 की बात करी, ठीक है. उसके बाद हमने बात करी सेक्शन 42 की, दैट इज डिसोल्यूशन ऑन द हैपनिंग ऑफ सर्टेन कंटीजेंसी सेक्शन 42. उसके बाद हमने बात करी डिसोल्यूशन ऑफ नोटिस सेक्शन 43 की, ये रहा डिसोल्यूशन ऑफ नोटिस सेक्शन 43 की. और हमने फिर जो बात करी सेक्शन 44 जो कि कोर्ट के द्वारा होता है. तो यानी 40 से लेके 44 तक के सेक्शनों के द्वारा हम डिसोल्यूशन ऑफ पार्टनरशिप कर सकते हैं. कोई दिक्कत नहीं होनी चाहिए. थोड़ा सा है, अगर आपने सेक्शन 41, 42, 43 के आगे आगे उनके मेन हेडिंग लिख दिए, मैं बता रहा हूँ आपको नंबर पूरे मिल जाएंगे. कोई नहीं पढ़ता अंदर का कंटेंट, आपको मेन हेडिंग ठीक करनी लिख देती है. डिसोल्यूशन बाय एग्रीमेंट, कंपलसरी डिसोल्यूशन, डिसोल्यूशन बाय हैपनिंग ऑफ द सर्टेन कंटीजेंसीज. तो चलो दोस्तों, अपना क्वेश्चन 3 भी डिस्कस कर लेते हैं. एक्सप्लेन द मेन फीचर्स ऑफ अ कंपनी form of a business. ठीक है. The company form of business is a distinct legal entity that is created and governed by a specific corporate laws like the Companies Act 2013 in India. भाई स्पेसिफिकली ये पेपर उनके लिए बहुत अच्छा है जो लोग अभी अपना फाइनेंस में एमबीए को अपना कोर ले रहे हैं, ठीक है. तो उनके लिए तो बहुत बेस्ट पेपर है. आप इसको अच्छे तैयार कर लो, आपका बेस बन जाएगा कि आपको इन सब चीजों के बारे में पढ़ना है. कंपनी एक्ट, पार्टनरशिप एक्ट, डिसोल्यूशन ऑफ पार्टनरशिप, इस सब के बारे में आपको बहुत पढ़ना पड़ेगा, क्योंकि बिकॉज यू हैव चूजन द फाइनेंस एज द मेजर, देन यू नीड टू थिंक अबाउट सच टॉपिक्स. तो इस टॉपिक को अच्छे से पढ़ो, ठीक है. It is a fundamentally different from other business structures like sole proprietorship or partnership, primarily due to the sophisticated legal framework and characteristics. These features make it suitable for large-scale operations, significant capital raising and long-term existence. देखो भोला भोला तिरुपति टाइल्स ये एक सोल प्रोप्राइटर है और इधर इट कैन बी पार्टनरशिप और इस नाम की आपको बतेरी कंपनियां मिल जाएगी. बट अगर कोई कंपनी आपको प्राइवेट लिमिटेड के नाम से आगे लिखा हुआ है या लिमिटेड नाम से लिखा हुआ है तो उस नाम की सिर्फ एक ही कंपनी होती है. ठीक है. फॉर एग्जाम्पल एबीसी टाइल्स लिमिटेड प्राइवेट लिमिटेड या लिमिटेड, इस नाम की सिर्फ एक ही कंपनी हो सकती है, दूसरी कंपनी नहीं हो सकती, क्योंकि वो प्राइवेट लिमिटेड कंपनी अपने आप को एक यूनिक आइडेंटिटी के साथ रखती है. तो आप पढ़ते हैं हियर आर द मेन फीचर्स ऑफ अ कंपनी फॉर्म ऑफ बिजनेसेस. ठीक है, पढ़ते हैं, बिल्कुल पढ़ेंगे, क्यों नहीं पढ़ेंगे, पढ़ने का है ना दोस्तों. सो पहला है सेपरेट लीगल एंटिटी और कॉर्पोरेट पर्सनैलिटी. This is perhaps the most defining characteristic. A company is legally distinct from its owners, shareholders, directors, and managers. It has its own legality identity, meaning it can own assets, incur debts, enter into contract, sue, and to be sued on its name, separate from its members. Implication: this separation protects the personal assets of shareholders from the company's liabilities and debts. If the company incur losses or face legal actions, only the company's assets are at risk, not the personal assets of the stakeholders or shareholders, unless there is a fraud or specific contractual arrangement. समझ में आ रही है? एक कंपनी जो है वो अपने आप में एक लीगल एंटिटी है, कॉर्पोरेट पर्सनैलिटी है. एक कंपनी के नाम पे आप प्रॉपर्टी खरीद सकते हो, एक कंपनी के नाम पे आप लोन ले सकते हो, एक कंपनी के नाम पे आप क्या नाम है अपना कोई असेट डिक्लेयर कर सकते हो. ठीक है. बट ऑब्वियसली अगर आप उसके डायरेक्टर होंगे तो आपके ऊपर भी उतनी ही चुनौतियां आती है. कोई भी कंपनी आपको लोन देती है तो वो आपके पर्सनल गारंटी भी ले ही लेती है. बट अगर आपने सिर्फ कॉन्ट्रेक्चुअल बेस पे लिया है, सिर्फ कॉर्पोरेट को अगर आपने लीगलिटी के तौर पे रखा है तो वो आपके पर्सनल एसेट्स पे हाथ नहीं डालेगी, ना उनको हाथ है, अनटिल अनलेस आपने कोई फ्रॉड ना किया हो. फिर है लिमिटेड लायबिलिटी. द लायबिलिटी ऑफ द शेयर होल्डर्स इज लिमिटेड टू द अमाउंट दे हैव इन्वेस्टेड और अग्रीड to invest, that is the unpaid value of their shares or the amount guaranteed. Their personal assets cannot be used to satisfy the company's debt or obligations. Implication: the feature is a major advantage for investors as it limits their financial risk, making investment in companies more attractive and encouraging capital formation. ठीक है. Limited liability. Perpetual succession. A company has or continuous or perpetual existence independent of the life or status of its members. The death, insolvency, resignation, or transfer of shares by any shareholders or director does not affect the company's existence. The company continues to exist until it is legally dissolved through the process of winding up. This ensures stability and continuity of operations, making long-term planning and project feasible. ठीक है. Artificial person. A company is a person in the eyes of the law, but not a natural human being. It is created by law and exists only through the legal fiction. As an artificial person, it can perform many actions that a natural person can, such as entering contracts, owning property, borrowing money, and suing and being sued. However, it cannot perform physical acts like eating, sleeping, signing documents, or other things. It acts through its human agents, directors and employees. सही है. साइन करेगा कौन करेगा? कंपनी थोड़ी साइन करेगी. कंपनी के बिहाफ पे उसके डायरेक्टर साइन करेंगे, जो उनके बोर्ड ऑफ डायरेक्टर्स डिक्लेयर करेंगे कि भाई बोर्ड ऑफ डायरेक्टर्स की मीटिंग बैठेगी, वो अपने डायरेक्टर्स को साइन करेंगे कि दैट दे हैव द पावर टू साइन द ड्राफ्ट ऑन बिहाफ ऑफ द कंपनी. ठीक है. फिर हमारा कॉमन सील क्लॉज, ऑप्शनल इन मैनी जुडिक्शन. नाउ historically, a common seal was the official signature of the company, acting as a physical embodiment and its artificial legal personality. Important documents of the company were authenticated by fixing a common seal. Implication: while mainly modern company laws have made the use of common seal optional, allowing authorized signatories to sign on behalf of the company, Its historical significance highlights the company's district and entity. देखो कॉमन सील क्लॉज ना 2000 से पहले बहुत चलता था। एक कॉमन सील क्लॉज आपके हर डॉक्यूमेंट में साइन करते थे जहां पर भी आपका लीगल एंटिटी की बात आती थी। फिर 2013 में जब नया कंपनी एक्ट आया, कंपनी एक्ट लॉ जो आया, उसके बाद से क्या हुआ, फिर इन्होंने बोर्ड ऑफ डायरेक्टर डिक्लेयर किए या कंपनी सेक्रेटरी या अदर डायरेक्टर्स मिलके एक ऑथराइज करते हैं किसी भी डायरेक्टर को जो उनको लीगली बाउंड करता है और डॉक्यूमेंट साइन करने के लिए। तो कॉमन सील का एप्लीकेबिलिटी अब उतना नहीं है, ये ऑप्शनल है कहीं कहीं किसी जुडिसिशन में, बट ज्यादातर नहीं है। फिर है ट्रांसफरेबिलिटी ऑफ शेयर एक्सप्लेनेशन ध्यान करते हैं। इन अ कंपनी लिमिटेड बाय शेयर्स, द ओनरशिप इज डिवाइडेड इनटू शेयर्स and these shares are generally transferable from one person to another. In public companies, shares are freely transferable subject to strong exchange rules. In a private companies, there might be some restrictions or transferability as specified in the articles of association. These features provide liquidity to investors, allowing them to easily buy or sell their ownership stake without affecting the company's operation. This makes it easier companies to raise capital from a broad base of investors. देखो पब्लिक लिमिटेड कंपनी में तो शेयर की डीलिंग आराम से हो जाती है। आपने भी देखा होगा, आपने भी पब्लिक लिमिटेड कंपनीज में शेयर खरीदे और बेचे होंगे जो भी आपके एनएससी या बीएससी पे लिस्टेड है। बट प्राइवेट लिमिटेड कंपनी में शेयर्स की डीलिंग जो है वो होती है आर्टिकल ऑफ एसोसिएशन के थ्रू। देखो फिर बता रहा हूं, मेमोरेंडम ऑफ एसोसिएशन क्या होता है कि कोई कंपनी इंटरनली कैसे काम करेगी और सॉरी बाहर कैसे काम करेगी एक्सटर्नल एनवायरमेंट में, और आर्टिकल ऑफ एसोसिएशन ये होता है कि कैसे वो इंटरनली काम करेगी। फिर है सेपरेशन ऑफ ओनरशिप एंड मैनेजमेंट, ये ना shareholders are the owners of the company, but due to the large number of shareholders, especially in public companies, and their diverse geographical location, it is impractical for them to manage the day-to-day operation. Instead of shareholders elect a board of directors who are responsible for the management and strategic direction of the company. मैंने बताया था ना बोर्ड ऑफ डायरेक्टर्स, तो क्या होता है, शेयर होल्डर तो हर कोई है, आपने भी एक शेयर ले रखा है रिलायंस का तो आप भी शेयर होल्डर हो, पर आप रिलायंस में सारे फंक्शन में जाके बात थोड़ी करने ले जाओगे, अभी सारी मीटिंग थोड़ी बैठोगे, आपके पास वोटिंग राइट्स है। बट बोर्ड ऑफ डायरेक्टर्स बने हुए हैं जो स्टेक होल्डर्स हैं, 51% से ज्यादा स्टेक लेके बैठे हैं, वो बोर्ड ऑफ डायरेक्टर्स डिसाइड करते हैं जो उस कंपनी के हाल भाव और चावल सब रेगुलेट करते हैं। दिस सेपरेशन अलाउ फॉर प्रोफेशनल मैनेजमेंट where experts can run the business efficiently. However, it can sometimes lead to agency problems where the interest of management may not always align perfectly with those of the shareholders. Capacity to sue and to be sued. भाई कंपनी पे केस हो सकता है और केस किया भी जा सकता है उसके द्वारा। As a separate legal entity, a company can initiate legal proceedings against others and can also be sued by others in its own name. This reinforces its distinct legal standing and allows it to enforce its rights and defend itself against legal claims. Raising capital, large capitals. The company form is well suited for raising substantial amounts of capital. It can issue shares to a large number of investors, public issue in the case of public companies, and also borrow funds through debentures, bonds, or loans. This access of diverse funding sources enables companies to undertake large-scale projects, expand operations, and invest in significant infrastructure or research, while might be possible for sole proprietorship or partnership. Statutory obligations in regulatory compliance. Companies are creatures of statute and are subject of extensive legal and regulatory requirements. They must adhere to strict rules regarding incorporation, share issuance, financial reporting, auditing, annual filings, corporate governance, and dissolution, as stipulated by the Companies Act and other relevant laws. This ensures transparency, accountability, and investor protection, but also means higher compliance cost and administrative burden compared to other business forms. कंपनी बनाई है तो कंपनी में बहुत ऑडिट होती है मेरे दोस्तों। अगर आप भी काम कर रहे होगे किसी ऑर्गेनाइजेशन में, देन स्पेशली इफ यू आर इन ऑडिट डिपार्टमेंट, देन यू नो लाइक हाउ मेनी ऑडिट्स आर देयर. LRM audit is there, internal audits are there, RBI audits are there, external audits are there. Every time, each and every time, your money is needs to be safe and it needs to be taken care by the others. That is the reason these audits are happening on day-to-day basis. So investors' amount doesn't get diluted and any kind of fraud can be detected and your hard-earned money can be saved. देखते हो ना, आए दिन कुछ ना कुछ निकलता है। कभी इंडसइंड बैंक के बारे में कुछ निकल जाता है, कभी पीएनबी बैंक के बारे में, कभी आईसीआईसीआई बैंक के बारे में कुछ निकल जाता है। बट आपका पैसा सेफ रहता है ओवरऑल। इसकी इंश्योरिटी करने के लिए आरबीआई बहुत कुछ कर रहा है। और ट्रस्ट में आज तक कोई भी बैंक नहीं डूबने दिया है, आरबीआई ने कोई भी वेल रेपुटेड बैंक को डूबने नहीं दिया है। दे हैड इंश्योर्ड कि 5 लाख रुपए तक का आपका वापसी आएगा। आई वुड सजेस्ट टू कीप up to 5 lakhs in any bank, or either open multiple bank accounts, so you will keep your money in diverse portfolios. कहीं भी किसी बैंक में 5 लाख रुपए से ज्यादा मत रखिए। सब अलग अलग बैंक में 5-5 लाख रुपए रख लीजिए, वो आपको हेल्प करेगा। So now let's discuss question 4, that is, describe the process of formation of a contract. Discuss the main characteristics that an offer proposal must possesses. Also explain the essentials of a valid acceptance. ठीक है। In law, a contract is a legally binding agreement between two or more parties that creates mutual obligation enforceable by law. The process of forming a valid contract typically involves several essential elements, most critically a clear offer and an unqualified acceptance. Process of formation of a contract. The formation of contract generally involves the following stages. First, offer or proposal. One party, the offerer or proposer, expresses a clear and definite willingness to do or abstain from doing something with the intentions of obtaining the assent of the other party, that is offering. Acceptance. The offeree signifies the unconditional assent to all the terms of the offer. This converts the proposal into a promise. Consideration. Something of value, a benefit, or a determinant is exchanged between the parties. This can be money, goods, service, or a promise to do or not to do something. Both parties must provide consideration for the contract to be legally binding. आप ज्यादातर जब जॉब करते हो, स्पेसिफिकली कहीं ना कहीं आप कॉन्ट्रैक्ट साइन करते ही हो, लीगली बाउंड होते हो। बट कहीं आप स्टैम्प पेपर पे अगर आप देख रहे हो कोई कंपनी आपको ज्वाइनिंग देने से पहले कोई स्टैम्प पेपर पे नोटरी पे अगर साइन करवा रही है, मेक श्योर कि आप उससे बहुत अच्छे से पढ़ो। ठीक है, आप एक कंपनी के लेटर हेड पे साइन कर रहे हो, दैट इज अ डिफरेंट थिंग। बट व्हेन गवर्नमेंट ऑफ इंडिया इज इन्वॉल्व while you are signing something over to a offeree, over to a proposer being your offeree, then you need to read that document carefully कि इसमें क्या ऑब्लिगेशंस आपके ऊपर डाली गई हैं। यदि आप जॉब छोड़ रहे हो तो आपको 30,000 रुपए पे करने पड़ेंगे। इस तरह की कोई अनवैलिड कंडीशंस है जिन्हें आप हटवाना चाहो तो बेशक आप बेझिझक के बोलीजिए, और इधर वो कॉन्ट्रैक्ट साइन मत कीजिए, क्योंकि वो आपको बाद में बहुत ही प्रॉब्लम करेगा। कॉन्ट्रैक्ट आपको लीगली बाउंड कर देते हैं, इसकी वजह से वो केसेस आपके ऊपर डालेगी। and then you need to pay because you had already agreed to do all those things जो उस कॉन्ट्रैक्ट में लिखी है। इनफैक्ट अगर वहां पे लिखा है कि आप 12 घंटे काम करोगे तो हमारे कैपेबल के हिसाब से तो 8 घंटे से ज्यादा काम नहीं लेना चाहिए। बट अगर उन्होंने लिखा है कि 8 आवर्स प्लस 4 आवर्स ऑफ एक्स्ट्रा आवर्स यू नीड टू वर्क इन द कंपनी, देन यू नीड टू वर्क 12 आवर्स। समझ रहे हैं? ये कॉन्ट्रैक्ट बहुत खराब चीज भी होती है यार, तो थोड़ा देख के पढ़ा कीजिए। फिर है हमारा इंटेंशन टू क्रिएट लीगल रिलेशंस। द पार्टीज मस्ट इंटेंड देयर अग्रीमेंट टू हैव लीगल कॉन्सिक्वेंसेस and to be legally enforceable. Social or domestic agreements are generally presumed not to have these intentions. Competency of parties' capacity. All parties entering into the contract must be legally competent to do so. This means they must be of legal age, of sound mind, and not disqualified by any law from contracting. भाई पागल माइनर बच्चे ये सबसे कॉन्ट्रैक्ट साइन नहीं वैलिड होता। एक अडल्ट हु इज possessing the age of 18 and above can only sign the contract. Then है हमारा lawful object and lawful consideration. The purpose, object of the contract and the consideration exchanged must be lawful and not forbidden by law, immoral, or opposed to public policy. Free consent. The consent of the parties must be free and not induced by coercion, undue influence, fraud, misrepresentations, or mistakes. Certainty and possibility of performance. The term of the agreement must be clear, definite, and not vague, and the agreement must be capable of being performed. Legal formalities, if any. While many contracts can be oral, Some specific types of contracts may require certain legal formalities. Example, writing, registration, attestation to be valid and enforceable. Example, contract for the sale of immovable properties. When all these elements are present, an agreement becomes legally enforceable contract. Main characteristics that an offer proposal must possess. An offer is the starting point of the contract for an offer or proposal as per Indian Contract Act 1972. देख रहे हो, आजादी से पुराना रूल है 1872, आजादी के पहले का रूल है भाई साहब, इसको ढंग से पढ़ लेना. Indian Contract Act 1872. To be valid, it must possess the following characteristics. First of all, must be communicated to the offeree. An offer is effective only when it comes to the knowledge of the person to whom it is made. An offeree cannot accept an offer of which they are unaware. If a offers a reward for finding a lost dog, but B finds the returns the dog without knowing about the reward, B cannot claim the reward. समझ में आ रहा है? बिल्कुल सिंपल बात है. जो जिसके लिए एप्लीकेबल है वही करेगा तो भी उसको इनाम मिलेगा. Must create legal relation. The offer must be made with the intention that if accepted, it will create a legally binding relationship between the parties. Social or domestic agreements are generally not considered to have these intentions. An invitation to a dinner party is not a legal offer. If accepted, it doesn't create a legal obligation. Obviously, समझ में आ रही है. पर if you have signed a joining letter, then you are legally bound. अगर आपने contract sign किया है, then you are legally bound to join that organization. Must be certain, definite, and not vague. The terms of the offer must be clear and unambiguous, leaving no room for confusion or speculation. If the terms are vague, a court cannot enforce them. Example, an offer to sell some of my goods is vague. An offer to sell 50 units of my Model X laptops is certain. May be expressed or implied. An offer can be made explicitly through words, spoken or written, or implicitly through contact. Express offer, I offer to sell you my car at 5 lakhs rupees. Implied offer, boarding a public bus implies an offer to pay the fare for the journey. May be specified or general. Made to a particular person for a defined group of persons. Only that person of group can accept it. General offer, made to the public at large. It can be accepted by any person who fulfills the condition of the offer. Example, reward for finding a lost item. Must be distinguished from form of an invitation to offer, a treat. An offer must express a final willingness to be bound, where an invitation to offer is merely an invitation to others to make the offer. Example, invitation to offer. Goods displayed in a shop window with price tags, advertisements for tenders, auction notices, a price list, a company's prospectus. Cannot contain a negative condition. An offer cannot state that if acceptance is not communicated by a certain time, it will be deemed accepted. Silence generally does not amount to acceptance. समझ में आ गई? ये नहीं हो सकता कि 7 दिन में अगर साइन नहीं किया कॉन्ट्रैक्ट तो मैं इसे एक्सेप्टेड मानूंगा ना. जब तक बंदा साइन नहीं करेगा तब तक मैं एक्सेप्टेड नहीं मानूंगा. Can be conditional. An offer can specify conditions that must be met for acceptance to be valid. However, acceptance cannot be conditional. Essential of a valid acceptance. Once a valid offer is made, the next crucial step is contract formation of its acceptance. For an acceptance to be valid and or convert a proposal into binding promises, it must satisfy the following essentials. Acceptance must be absolute and unqualified. Mirror image rule. The offeree must agree to all the terms of the offer without any modification, addition or condition. If any changes are proposed, it becomes counter offer which terminates the original offer. समझ में आ गई? आपने फिर दोबारा लिखे जाना है, फिर कॉन्ट्रैक्ट दोबारा रिवाइज होगा और उस पर साइन करने हैं, पुराने वाले पे नहीं साइन करेंगे. Offer to sell a house of 50 lakhs. B replies accept, but only if this includes furniture. This is a counter offer, not a valid acceptance. Acceptance must be communicated. Acceptance must be communicated to all the offerer. Merely mental assent or uncommunicated intentions to accept it not sufficient. If A sends an offer to B and B decides to accept it but doesn't tell A, there is no contract. Exception. In a general offer, performance of the condition of the offer can constitute acceptance without formal communication. Example, Carly versus Carbolic smoke ball co case. Acceptance must be in the prescribed form mode, if any. If the offerer specifies a particular mode of acceptance, example reply by email only, the acceptance must be communicated in that mode. If no mode is prescribed, acceptance can be usual and reasonable manner, example by post, email, verbally, depending on the context. Acceptance must be given with the reasonable time. If a time limit acceptance is specified in the offer, acceptance must be given within the period. If no time is specified, it must be given within a reasonable time, which depends on the nature of the offer and the circumstances of the case. Acceptance must be by the offeree or their authorized agent. Only the person or persons to whom the offer was made can accept it. Acceptance by anyone else is not valid. Acceptance cannot precede the offer. Acceptance must always follow the offer. One can not accept an offer that has not yet been made or communicated. Silence is not acceptance. The offerer cannot impose a condition that the offeree's silence will be deemed as acceptance. Acceptance must be made before the offer lapses or revoked. An offer can be revoked by the offerer at any time before it accepted. Once the offer lapses due to expiry time or death of the offeree, it cannot be accepted. By ensuring the both the offer and acceptance meet these characteristics, parties can form legally binding contracts. So दोस्तों क्वेश्चन 5 हम डिस्कस करते हैं. What is the objective of the Foreign Exchange Management Act? Discuss the mechanism for acquiring property in India by non-resident and outside India by a resident. समझ रहे हो? नॉन रेजिडेंट या आउटसाइड इंडिया बाय अ रेजिडेंट, उनके लिए कैसे वो फॉरेन यहाँ पे एक्वायर कर सकते हैं प्रॉपर्टी. दैट इज फेमा, फॉरेन एक्सचेंज मैनेजमेंट एक्ट. ऑब्जेक्टिव ऑफ द फॉरेन एक्सचेंज मैनेजमेंट एक्ट, और जिसे हम फेमा बोलते हैं, द फॉरेन एक्सचेंज मैनेजमेंट एक्ट 1999, FEMA, is a landmark legislation in India that replaced the highly restrictive Foreign Exchange Regulation Act 1973. समझ रहे हो? फेरा के बदले में आया था फेमा. पहले क्या था? फॉरेन एक्सचेंज रेगुलेशन एक्ट 1973, जो बाद में बदल के किसमें? फेमा में. फॉरेन एक्सचेंज मैनेजमेंट एक्ट 1999. द प्राइमरी ऑब्जेक्टिव ऑफ फेमा इज टू facilitate external trade and payments and for promoting the orderly development and maintenance of foreign exchange market in India. In essence, FEMA was introduced to liberalize and deregulate the foreign exchange regime in India, aligning it with the country's economic reforms and global trade commitments like those under the WTO, World Trade Organization. Key aspects of this includes facilitating external trade and payments. FEMA aims to simplify the rules and procedures for international trade and transaction, imports and exports, and other cross-border payments, making it easier for Indian businesses and individuals to engage with the global economy. ठीक है भाई, समझ में आ गया? बाहर से सामान मंगाना और बाहर सामान भेजने के लिए ईज करने के लिए फेमा को लेके आए. Promoting orderly development and maintenance of foreign exchange market. It seeks to ensure that the foreign exchange market in India operates smoothly, transparently, and efficiently, facilitating the foreign currency transaction and fostering a stable exchange rate. This involves regulating authorized dealers, banks, and other financial institutions who deal in foreign exchange. Managing, not regulating. Unlike FERA, which has a highly restrictive regulation act, presuming everything was prohibited unless specifically permitted, FEMA is a management act, presuming everything is permitted unless specifically prohibited. These shifts reflect a more liberal approach towards foreign exchange transactions. Ease of doing business. By providing a clear, transparent framework, FEMA aims to attract foreign investments to India and encourage Indian residents to invest abroad, thereby promoting economic growth and integration with the global economy. Differentiating current capital account transactions. FEMA clearly distinguishes between current account transactions related to trade, service, income, remittance, or expenses, and capital account transactions related to assets and liabilities like investment and property. While current accounts transactions are generally free, capital accounts transactions are regulated by the RBI with specific permission or general permissions like the liberalized remittance scheme. Mechanisms for acquiring property in India by a non-resident and outside India by a resident. FEMA and the regulation frame the thereunder by the RBI govern the acquisition and transfer of immovable property in India by person resident outside India and outside India by person resident in India. Acquisition of immovable property in India by a non-resident. The non-resident offers person resident outside India. This typically includes NRIs, OCIs over citizens in India and foreign nationals. General permission, no prior RBI approval required subject to conditions. NRIs and OCIs, permitted properties, can acquire any immovable property in India other than agricultural land. समझ में आ गई? NRI और OCI कार्ड होल्डर्स कोई भी जमीन खरीद सकते हैं एग्रीकल्चर लैंड को छोड़कर. आपके शहरों में कोई जमीन खरीद सकते हैं, फ्लैट खरीद सकते हैं, विला खरीद सकते हैं, बट वो एग्रीकल्चर लैंड नहीं खरीद सकते. फार्म हाउस भी नहीं खरीद सकते. फार्म हाउस भी नहीं खरीद सकते. प्लांटरी प्रॉपर्टी मतलब फार्म वगैरह में लैंड नहीं खरीद सकते. फ्लैट, विला, होम्स, ये सब चीजें खरीद सकते हैं. Modes of acquisition, purchases, the consideration must be paid out. Funds received in India through normal banking channels. Inward remittance from outside India. ठीक है. Funds held in non-resident external NRE account, NRE account and NRO account, non-residently ordinary account or foreign currency non-resident FCNRB account. Important note, payment cannot be made by traveler's check or foreign currency notes. Gift can acquire property other than agricultural land, farmhouse, plantation property by way of gift from a person resident in India. An NRI or an OCI card provide the donor is a relative as defined under the Companies Act 2013. Inheritance can inherit any movable property in India from a person resident in India or a person resident outside India who had acquired the property as per FEMA regulation. Sale of such property, they can sell such property to a person resident in India. They can also sell non-agricultural property to another NRI or OCI. Agricultural land, farmhouse, plantation property can only be sold to a resident India. Repartition of sale proceeds. Sale proceeds of residential properties can be repatriated outside India, generally limited by two such properties, up to $1 million per financial year, inclusive of other remittance amounts from narrow accounts, etc., after payments of applicable taxes. Foreign national of non-Indian origins resident in India. A foreign national, not an OCI, who is a person resident in India, as per FEMA. Definition of a resident is generally staying in more than 180 days in a financial year, can acquire immovable property in India, but would typically require specific approval for agricultural land, farmhouse or plantation property. Foreign embassies and diplomat consultants can purchase sale immovable property in India other than agricultural land, plantation, farmhouse with prior clearance from Government of India, Ministry of External Affairs and payment through banking channels. Foreign companies with a branch, project, license office in India. A branch or project office, excluding license office of a foreign company established with the requisite approvals, can acquire immovable property in India that is necessary or incidental to carrying on their authorized activity. Specific permission prior to RBI approval required. Citizens of certain countries like citizen of Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, Macau, Hong Kong, Nepal, Bhutan or Democratic Republic of Korea (DPRK), irrespective of their residential status, cannot acquire or transfer immovable property in India other than a lease not exceeding 5 years without prior approval from RBI. ठीक है, इन कंट्रीज में से भाई कोई बंदा घर नहीं खरीद सकता RBI के अप्रूवल के बिना. Foreign national of non-Indian origin resident outside India, generally they are not permitted to acquire any movable land in India unless it is by way of inheritance from a person who has resident in India or a lease not exceeding 5 years. Any other mode would acquire specific RBI permission. Acquisition of immovable property outside India by a resident. Resident refers to a person resident in India. General permission, no prior RBI approval required, subject conditions. Under liberalized remittance scheme, LRS, resident individual can remit funds up to specified limit, currently USD 250,000 per financial year for various purposes, including the purchase of immovable property outside India. This limit is cumulative of all remittance by an individual in a financial year. Joint acquisition. Resident individual can pool the LRS remittance with a family member to purchase joint property overseas. Acquisition while being a non-resident. A person who was resident outside India earlier can continue to hold on or transfer any movable property situated outside India if such property was acquired or held by them when they were a resident outside India. Okay. Inheritance. A resident India can acquire a movable property outside India by way of inheritance from person resident outside India or from a person resident in India who had acquired such property as per existing foreign exchange provisions. Gifts can acquire property outside India by way of gift from a person who had acquired it as per the foreign exchange provisions in force at the time of such acquisition, provided the donor is a relative as a defined. Purchase out of RFC account. A person resident in India may acquire movable property outside India by way of purchase out foreign exchange held in their resident foreign currency RFC account, which can be maintained by those who were non-residents and have returned to India. Indian entities and overseas office. A company incorporated in India having overseas office, example branch or project office, may acquire immovable property outside India and its business purposes to residency purpose for its staff in accordance with the RBI direction. Specific permission, prior RBI approval, any other mode. Any acquisition of immovable property outside India by a person resident in India that does not fall under the general permission category requires specific prior approval from RBI. FEMA aims to facilitate but not entirely free foreign exchange transactions. The RBI retains significant powers to regulate capital account transactions like property acquisition to maintain macroeconomic stability and prevent speculative flows. Always refer the latest FEMA regulation and consult the financial and legal experts. दोस्तों क्वेश्चन 6 डिस्कस करते हैं. Explain the necessity for the Insolvency and Bankruptcy Code 2016 IBC 2016, that is Indian Insolvency Bankruptcy Code IBC 2016, and briefly discuss the 4 pillars of the institutional infrastructure under IBC 2016. Necessity for the Insolvency and Bankruptcy Code 2016. Insolvency बोले तो दिवालिया, bankruptcy or insolvency. Before the enactment of the Insolvency and Bankruptcy Code IBC 2016, India's insolvency and bankruptcy framework was fragmented, inefficient, and highly complex. Multiple laws and overlapping jurisdiction led to significant delays in resolving stressed assets, resulting in low recovery rates for creditors and detrimental impacts on the Indian economy. The necessity for IBC 2016 arose from several critical issues. पहला था fragmented and overlapping laws. Prior to IBC, insolvency was dealt under plethora of laws, including Companies Act 1956-2013, Sick Industrial Companies Special Provision Act 1985, SEICA, Recovery of Debts Due to Banks and Financial Institutions Act 1993, Securitization and Reconstruction of Financial Assets and Enforcement Act, that is Act 2002, सरफासी जिसे बोलते हैं, सरफासी एक्ट, ठीक है, सरफासी एक्ट, और प्रेसिडेंशियल टाउन इंसॉल्वेंसी एक्ट 1909, प्रोविंशियल इंसॉल्वेंसी एक्ट 1920. इसके अंडर में पहले बहुत सारा रूल शुरू होता था, जिसके बाद अब तो अगर आईबीसी 2016 आ गया. Delays in resolution. The previous regime was notorious and its inordinate delays. Resolution processes would drag on 4 years, sometimes even decades, leading to severe value erosion of assets. This debtor in positions regime often allowed promoters to retain control even after defaults, further exacerbating the problem. Low recovery rates. Due to prolonged delays and value erosion, creditors, especially banks, faced very low recovery rates on their non-performing NPAs. This significantly impacted the balance sheet of banks and restricted the availability of fresh credit for healthy businesses. Inefficient exit mechanism. There was no effective and time-bound mechanism for the closure of failed businesses. This meant that capital remained stuck in the unproductive assets, hindering resources reallocations and entrepreneurship. Creditor disadvantage. The existing laws were often seen as the favoring debtors, making it difficult for creditors to initiate effective recovery or resolution proceedings. The power dynamics were skewed. Lack of creditor in control framework. The old regime did not effectively shift control to creditors upon default. IBC fundamentally changed this by empowering a committee of creditors (COC) to take decisions regarding the corporate debtor's future. Need of time-bound process. A critical requirement was to introduce a strict timeline for the insolvency resolution process to prevent value erosion and ensure quick decisions. Promoting ease of doing business. An efficient insolvency regime is crucial for improving countries' ranking in the ease of doing business index as it provides certainty to investors and lenders. In essence of IBC 2016 was enacted to consolidate and amend all laws related to recognition and insolvency of resolution of corporate persons, partnership firm and individuals in a time-bound manner, with the primarily objective of maximizing the value of assets of such persons, promoting entrepreneurship, increasing the availability of credit, and balancing the interest of all stakeholders. It shifted the focus from merely liquidating assets to rescuing viable businesses. Four pillars of institutional infrastructure under IBC 2016. पहला था Insolvency and Bankruptcy Board of India, that is IBBI. Insolvency and Bankruptcy Board of India, IBBI. और दूसरा था इंसॉल्वेंसी प्रोफेशनल्स आईपीस, तीसरा है इंफॉर्मेशन यूटिलिटी आईयूज, और चौथा है एडजुकेटिंग अथॉरिटीज। इसके बारे में थोड़ा सा पढ़ लेना, ठीक है, अपने आप आइडिया लग जाएगा। अब पढ़ते क्वेश्चन 7। Discuss the role of privacy in the context of digital world. Briefly discuss the Personal Data Protection Bill 2019. The role of privacy is the context of the digital world. In the digital world, privacy has evolved from a simple concept of being left alone to a complex web of rights and responsibility concerning personal data. Its role is fundamental and multifaceted, impacting individual, business and society at a large. Here's why privacy is crucial. क्योंकि भाई protection of individual autonomy and freedom, ठीक है, prevention of misuse and harm, building trust and confidence, maintaining personal security, ethical business practice and accountability, democratic value and social equity। ठीक है भाई, अंदर का चीजें तुम पढ़ लेना, मैं सिर्फ हेडिंग नहीं पढ़ा रहा हूँ, क्योंकि हेडिंग अगर सही लिख दी, अंदर का कंटेंट अगर ऊपर नीचे होगा तो भी चलेगा मेरे दोस्तों, ठीक है। हेडिंग हेडिंग याद करने का, लिखने का, बिल्कुल झाड़ लगाने का, पेड़ लगाने का, ठीक है, अच्छे से याद करने का सारी हेडिंग्स को। In essence of the privacy, the digital world is a fundamental human right that underpins personal security, individual autonomy, economic trust, and democratic principle. As technology advances, the data collection and robust privacy frameworks become increasingly vital. Personal Data Protection Bill 2019, PDP Bill 2019, क्या था भाई ये? The Personal Data Protection Bill 2019 was a significant legislative effort in India aimed at providing a comprehensive framework for data protection. It was drafted based on recommendation of the Justice Beyond Sri Krishna Committee, which was constituted in the wake of the Supreme Court's landmark Puttaswamy judgment 2017 that declared the right to privacy as a fundamental right under the Indian Constitution. Status of the bill. The Personal Data Bill 2019 was withdrawn by the Indian government in August 2022. The government stated that it would introduce a new, more comprehensive legal framework to regulate the digital ecosystem, including a new data protection bill that withdraw the outcome after existing deliberation by joint parliamentary JPC, which proposed numerous amendments over 18 years of recommendation. The primary reason to withdraw cited by the government observed included too many amendments, compliance burden, to data localization provisions, broad government exemptions, inclusion of non-personal data. The Digital Personal Data Act 2023 was passed by the Indian Parliament in 2023. Key replacing the 2019. Key provision of the personal data withdrawal applicability. कैसे थी? By government, by foreign companies, by it had extraordinary applications. Categories of data: personal data, sensitive personal data, critical personal data, data fiduciary and data principal. Data fiduciary, an entity, individual or company that determines the purpose of means of processing personal data. Data principal, the individual which is person process the data owner. Ground for processing personal data: security of the state, prevention of investigation, medical emergencies, for providing benefit for individual to state credit scoring. Rights of the data principal: rights to confirmation and access, rights to correction and erasure, right to data portability, right to be forgotten, obligation of data fiduciary, purpose of limitation, collection limitation, storage limitation, security safeguard, data protection officers, DPO, data protection impact assessment, DPIA, reporting data breaches, data localization. Sensitive personal data was required to be stored in India. Critical personal data to be defined by the government. Data protection autonomy, DPA. Penalties, stipulated significant penalties for violation, including fines up to 50 crore or 4% of the worldwide turnover of the data, particularly for serious contraventions. While the Personal Data Protection Bill 2019 was withdrawn, its spirit of many its concepts have influenced the subsequent Digital Personal Data Protection Act 2023, which is now India's governing law on data protection. लास्ट क्वेश्चन है क्वेश्चन 8, इसके बारे में थोड़ा पढ़ लेते हैं. Explain the applicability of consumer protection e-commerce rules 2020 and discuss the duties and liabilities of e-commerce entities under this rule. The Consumer Protection E-commerce Rules 2020 were notified in the central government of India under the Consumer Protection Act 2019 to regulate e-commerce transactions and protect business consumer interests in the online market. These rules aim to ensure transparency, fairness, and accountability in digital retail. Applicability to Consumer Protection E-commerce Rules 2020. These rules have a broad scope to apply. All goods, service brought or sold over any digital or electronic network, including digital products. All models e-commerce marketing, e-commerce entities, inventory e-commerce entities, all e-commerce retail, all forms of unfair trade practice across all models of e-commerce. Crucially, these rules also apply to e-commerce entities that are not established in India but systematically offer goods or services to consumers in India. Exemption. These rules generally do not apply to the activities of a natural person carried out in a personal capacity, not being part of any professional or commercial activity undertaken on a regular systematic basis. Duties and liabilities of e-commerce entities under this rule. The rules impose the duties of liability different types of e-commerce and consumer rights. General duties of e-commerce entities, incorporation and nodal person. ठीक है. Second है information disclosure. Third है grievance and redressal mechanism, information of imported goods. No unjustified cancellation charges, explicit consumer consent, timely refunds, no price manipulation, national consumer helpline. Specific duties and liability of marketplace e-commerce entities, seller information, seller undertaking, information on returns, refunds, etc., ranking parameters, fallback liability. Specific duties and liabilities of inventory of e-commerce, comprehensive product information, mandatory notices, payment information, total price disclosure, complaint tracking, no fake review, consistent advertisement, returns and refunds for defective goods. Authenticity liability. In essence, the Consumer Protection E-commerce Rules 2020 significantly strengthens consumer protection in the digital sphere by mandating transparency, spelling clear grievance, redressal mechanism, and holding e-commerce entities accountable for the goods and services offered on their platforms. तो दोस्तों खत्म हो गया हमारा MMPC 13 का ये वीडियो, और होपफुली हम लोग दिसंबर 2023 का भी वीडियो डिस्कस कर पाएंगे. लेट्स सी. टिल द टाइम स्टे वॉच दिस वीडियो. अगर आपने अभी तक देखा है तो लाइक करिएगा, शेयर करिए.